Yeah. All right, you ready?
I'm ready.
All right. This is PhiLAWsophy, podcast about law and philosophy. My name is Brenton Begley, and I'm here with Therron Causey, the cause.
Hello.
Hello. All right, so today we're talking about, we jumped straight from the death penalty, right to the Second Amendment. That's what we're doing, because we don't care. We'll talk about it, man.
Yeah, I mean, why not just jump right in the deep end?
Next thing we're going to talk about is religion. So strap in for that. We don't care. All right, so let's do it. Let's talk about the Second Amendment. We have a little outline going for this episode. We want to talk about the Second Amendment, basically, what it says, what it means. I mean, I don't know if a lot of people know what the text of the Second Amendment says. There's a lot of controversy around the Second Amendment, a lot of, controversy around the text of the Second Amendment. And it comes down to what type of approach to constitutional law that you take. So,
well, let me just clear the air for anybody curious, okay? And I quote, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed."
All right. Right. Interesting. So those are broken down in that text is broken down into basically two parts. Right. You have the first part saying it's, a well-regulated militia being necessary for whatever it says. And then the second part saying the rights of the people to keep and bear arms shall not be infringed.
That's right. And I think that, Brenton, there's some commas in there. And the placement of those commas have been the point of much litigation. Wouldn't you agree?
Yeah, certainly. Because it really matters where you place your commas. I mean, those founders, they'd be placing commas everywhere.
That's right.
I don't know if they had a strong syntax background, but because they'd be throwing some commas and colons and maybe some
like future
in there. So I mean, if we're using commas or punctuation to set off what they mean, then we might not actually derive their meaning. But hey, that's just one man's opinion. However, yeah, it's been the source of some controversy, and really, you have the first clause in there saying, okay, well, it's good to have a well-regulated militia. And why is it good to have a well-regulated militia? Well, the founders, they figured, well, we did pretty well with a well-regulated militia because, we wanted to ensure that the government that was ruling us, right, did not force us into experiencing, the tyranny of King George at the time, right? We didn't want to have to be subjected to that tyranny any longer. So it was very important for us to have a well-regulated militia to be able to fight that, tyrannical government. And so, for them, that was a big thing. If the people have power, if you're really going to empower the people and have a democracy, a true democracy where it's of the people, by the people, for the people, then the people should probably have a check on the government, and that check being the ultimate check, the check of being able to overthrow the government if it becomes tyrannical.
So I Brenton, if I can jump in, I definitely think that's an underlying theme and a closely held belief for a lot of folks that would be, considered pro Second Amendment. But if we back up and we look at, the way that is all put together, right, in the Second Amendment, all those words put together like they are,
right.
Our founding fathers suggesting that the right to keep and bear arms is something that should be acknowledged, but only with some sort of state-backed militias for self-defense? Or were they suggesting that everybody in the nation at that time had a right to keep a gun for their personal use, for their personal protection? Right?
Yeah, and that's a great question. And the other question is, I mean, man, is a well-regulated. Well, yeah, I'm going to keep doing that. Keep messing up over that thing. Well-regulated militia, if that is necessary, not only to overthrow your own government to prevent from tyranny, right, which is a radical, pretty amazing idea, to ensure liberty and freedom, but also for the protection of national security. Because they didn't have a standing army at the time.
That's
Right. Back in the day, like around the time that they were founding the country, you'd whip up an army, and then after you're done with the war, you disband the army. Everybody would go home, and you don't have professional soldiers. Now that's not a thing, right? We have a standing army all the time. And
That's right. And so really what that evolved into, right, over time, and like we said, it's been the source of controversy over time, and we've sort of wavered on that, right, and what that means and how to apply it. And I think that that's a good segue into a more recent Supreme Court decision, Heller versus District of Columbia, right, where the Supreme Court sided with the idea of how to apply the Second Amendment. That in a 5-4 decision, and correct me if I'm wrong on that, that basically individuals, the Second Amendment applies to an individual's right to own firearms. And that's the current standing precedent with respect to the Second Amendment.
Yeah. And, I think you're right there with the 5-4 decision. Scalia wrote the opinion, good old Scalia, God rest his soul. And a brilliant Supreme Court justice who was a traditional originalist and textualist. And we'll talk a little bit more about that. But his reasoning in that decision, District of Columbia versus Heller, or Heller versus District of Columbia, I forget which is which. They were adverse parties for sure. The reasoning there for him was, he was like, hey, we have this first clause here, but this clause is just kind of giving a purpose for why the rights of the people to keep and bear arms shall not be infringed, but it doesn't limit the scope of the second clause, right? The first clause, just giving a purpose, doesn't in any way limit the scope of the second clause. I mean, because, that second clause is, it's in the words of Moses in the Big Ten, it's shall. Mm-hmm. So, those are pretty strong words, especially if you're an attorney, you read shall. That's pretty straightforward to you.
Must.
Read something like that. Yeah, you must. It is set in stone. It is,
right.
The rights of the people of the United States to keep and bear arms shall not be infringed. And so, that's his take on it. And that's the court at the time, that's their take on it. That, hey, you have this, prefatory clause, but really just giving us a reason why they are so strong in their language for the second clause.
Right, and I think that tying back into the purpose, or really maybe the mindset of these people that drafted this, right? They say, okay, we see this as a must, right? It's we have to make some sort of point on this, right? And if you look at some of those founding fathers and what they're talking about, I think that the intent there is clear, a clear preference that there should be a right to own a firearm. I know that George Washington once said that a people who are free ought not only to be armed but also disciplined, right? So he understood that he believed that should be part of society, right? Thomas Jefferson wrote that men should never be debarred from the use of firearms. Benjamin Franklin, another founding father, suggested people who were willing to give up liberty for sanctioned security, right, deserve neither. So those are really, I think, consistent ideas and philosophies, for lack of a better term, that really were the underlying, the underpinnings of the Second Amendment.
Man, what you said, quoting Benjamin Franklin, that's a good quote. It's a good quote. I like that quote. And that really, it takes it off topic, but, it really brings to mind the level of privacy that we've lost as individuals just in general, not even in this country, just as a
Illinois,
global
too,
system,
for that matter.
and how we've just let it happen. But hey, that's for another time.
Your right to privacy. Let's make sure that's episode 3 or 4.
Okay, right to privacy. Let's write that down. So
Yeah,
exactly. So the other thing is, I mean, it's pretty clear that the founding fathers thought that individual citizens should have guns. Okay, and the other thing is, or firearms generally, probably should be disciplined too, by the way, but have firearms. And the other thing is, what they were pulling from the state constitutions too. These different states made their own constitutions, and they're pulling from these state constitutions that did give and contemplate individual rights to keep and bear arms. And so it's pretty clear that at that time, that was the intent. So it's correct if you're Scalia and you're taking a textualist or originalist approach to the Constitution.
So talk a little bit more about that when you talk about textualist versus originalism. Textualism, originalism. Can you break that down for anybody?
Well, textualism and originalism are kind of interchangeable, but it contrasts with the other approach to reading the Constitution as a living document, a living, breathing thing that it evolves. So, which technically speaking, a Constitution that allows for amendments is a living, breathing document with respect to how it's updated and amended.
There's a process,
but there's a built-in process for that. But a person who's not a textualist, not an originalist, will look at the Constitution and see it as a living, breathing document where it's the role of the judge, what we would sometimes call an activist judge, to expand the scope or have the current constitutional law changed to meet the times and the culture and the social mores that we hold now, as opposed to what was valued before, or what was perceived to be valued before. Whereas textual and originalism is saying, hey, this is the Constitution, it has a certain amount of reverence, this is what we need to follow. The plain text is there for a reason, it was written that way for a reason, we should read that and derive also the original intent. And that's where originalism comes in. Textualism is basically the black letter law, and the originalism is getting that original intent that the writers of the black letter law had when they put it down on paper with an ink and quill.
Sure. So I mean, really, what you laid out there is two ways of looking at the world, or the guiding document that is sort of the light, the candle in the darkness, right, for the great American experiment,
right?
And how to best understand what has been provided as that guide, right? How to interpret that. If it's sticking to the letter, shall not be infringed, right? If it's as strict as that, or is there some room for interpretation? And should that change over time? What would be the advantages or disadvantages of swaying interpretation to the masses? And I think that what you're looking at too, there's something that really was a light bulb that went off over my head as you were talking about. There's something in the legal field, the legal profession, called stare decisis, right? Which is really this phrase that determines that determining points in litigation, right, is made in accordance with precedent. Okay, so the decisions that have already been made, and we do that because there's value in consistency, right? But there's certainly, I think that it has to be a healthy mix of both yin and yang here, right? Because at some point, what was once precedent will become potentially, something that's overturned, and then you have a new direction, right? And so there should be some room for growth, but the tendency, nonetheless, should be to stick with what we know for the same rationale or the same reasoning that has prevailed over time.
That, and the other reasoning behind that is kind of like what a girlfriend tells me sometimes, is stay in your lane, right? I mean, this country is founded on a principle of checks and balances. We all learned that in our social studies class, right?
You're talking to the judiciary there when you
That's
say
right. So,
right?
yeah, judiciary needs to stay in your lane. There's a Congress for, if you want to change the law, that's what Congress is there for, and so when the judiciary starts doing the job of Congress, it starts to get dangerously close to legislation. And the thing is, the reason why I say it's dangerous is because you don't want any one branch to have too much power, because they get too powerful and that can become tyrannical. I mean, if we just look to the judiciary to make the law, then that's absolutely a problem. It's absolutely a problem, because we have a whole other branch of government that's not doing their job, right? So that means that there's an issue somewhere, because we've set up this well-functioning government that should be able to, function in the way that it's set up. And if it's not set up, it's not actually acting that way, then that can be an issue. So really, the best type of government is a government that, where in their branches, right, their separate branches, like we have 3 branches, we have the executive, the judiciary, and the Congress, right, that they have a check on themselves too, that they limit their power, their scope of power, and their willingness to go beyond a certain spectrum, right? So the judiciary should always be incredibly careful about how they assert their ability to change the law. And that's where stare decisis came in. They said, okay, well, it's not our job to legislate. And so we have to have something. We have to have a basis for our decision making. So we're going to say that, hey, this was the law, how it was interpreted initially. And so that created a basis, that created a precedent, that created a foundation for which we have to first acknowledge before we can change, just on our own and make something up.
Right.
And that's incredibly important to have those limited roles in government.
I agree. And I think that is a good segue into, talking about fundamental rights, right? And the preservation thereof. Right. It's the role of the government to, anything that's considered a fundamental right, should be held closely with the safest of regard. And the government should be held to the strictest of standards, right? And I'm sure you'll talk about strict scrutiny, what that means. If you want to infringe on some sort of fundamental right, there has to be some sort of, overriding interest that's going to push back against your interest as an individual in maintaining that fundamental right.
Exactly. So to contextualize what we're talking about here is, you can say, okay, it's all well and good that we have the Second Amendment. And I accept that, if you take an originalist look at it, that the founders intended for individuals to have individual right to keep and bear arms. And then also, I accept your point that the judiciary themselves shouldn't change that. We shouldn't rely on the judiciary to do that judicial activism. And let's just assume you agree with all that. Your response might be then, okay, well, the Second Amendment is not a wholly, 100% untouchable right that is just absolute, because any right that you have, the government can, in theory, infringe upon if they have a compelling interest, and the way in which they infringe upon that right is narrowly tailored, and that's strict scrutiny, right? So your speech can be limited.
Here's a great example, right? First Amendment, when that captures the right, the free can't walk into an airport and start yelling bomb.
That's right.
Makes sense from a very practical perspective. It makes sense.
Right. There's a compelling government interest there. You don't want people to stampede. You don't want people to freak out. You don't want there to be a breach of security. And then it's narrowly tailored to certain words. You can go in an airport and yell things. When you start yelling bomb, it's not good. You start yelling, I hate Delta, then everybody's going to get it and no one's going to do anything to you. So it is narrowly tailored. So that's a great example, but the thing is that you're right. This hypothetical devil's advocate that I'm imagining here is like, hey, guys, remember, the Second Amendment is not an absolute, because there is no absolute right that you have that can't be infringed upon in some way. So, that leads a lot of individuals to say, hey, okay, well, we have the Second Amendment right, but, and I know the legislature is supposed to do their job. The judiciary is not supposed to be the ones who legislate, but let's be real here. If New York wants to not allow people to carry guns, if DC wants to not allow people to carry guns, and that's the culture there, then we should be able to, adopt that culture because there's a compelling government interest. What about crime? What about violent crime? Isn't that a compelling government interest?
Absolutely. Yeah. I mean, without a doubt, the general welfare of the people.
Yeah. But then you look at it, okay? General welfare of the people is certainly a compelling interest. But, is limiting, let's say, take the Heller case, for example, is limiting the ability to own a gun narrowly tailored? Scalia didn't think so, and 5 of the justices didn't think so, right?
But
and so,
or did, right?
Yeah.
So you can see how easily that people can disagree on these kind of points, right? Because I mean, everybody's coming from different perspective, right? Different. I mean, it's a cross section of the American populace, and you're going to get people that have that are just completely different, right? From all walks of life, different cultures and different backgrounds, maybe with different values. And I think that goes a lot into what you're talking about, Brenton.
That's right. That's right. And despite your view on the Second Amendment, and to kind of circle back to what you were saying initially about fundamental rights, despite your view on the Second Amendment, it is a fundamental right laid out in our Constitution. And this is an important point to make, that even if you don't like one of the fundamental rights that we have, they should still be jealously guarded. Because if we let one fundamental right just be done away with because we don't like it, then what's to say that you can't do the same thing with another fundamental right? I mean, you just talked about stare decisis. We just talked about precedent. You set a very dangerous precedent when you look at one of the fundamental rights and say, okay, well, we should skip the whole strict scrutiny thing and just go for the neck.
Yeah, and that's that slippery slope argument. That you'll hear people talk about a lot of times, and it's sort of in a way an alarmist approach, but not in a negative light. In that it's a reality that if you allow the government to start infringing on these fundamental rights, right? Your right to the First Amendment, guaranteed by the First Amendment, Second Amendment, and so on. If you allow them to infringe on, say, those rights, maybe during an emergency, for instance, right? Then they'll start creating emergencies to take away your rights, right? And that's my perspective on it. Is you give them an inch, they will take a mile.
Well, I mean, you're with the risk of us both sounding like rampant libertarians taking that position. I mean, that was what was contemplated when this country was created. If you look at just how power works in general, what a fundamental right does is it sets and fills the vacuum, the void of power. Okay, which if you take that away, will then be filled with something else.
Right.
Okay. And what is the Constitution? What is the Bill of Rights? The Bill of Rights is an incomplete enumeration of our individual rights, to where the government cannot infringe upon those rights just without a good reason and narrowly tailored and all that good stuff. So, but generally they can't infringe upon those rights. So if you think about what that's doing, if you take away one of those fundamental rights, who fills that vacuum? The government.
Yeah.
Because then they have the power to say, okay, well, you no longer have that right, so I can infringe all I want to on what is no longer considered a right.
Sure.
And it's an incredibly important thing. I mean, that's one of the things, I'm going to say it, I don't care. Abortion. Abortion is a real hot topic, but I will say this about abortion, okay? And we'll skip the rest. It's important to consider that, I mean, and a lot of people don't consider this. A lot of people may hear this and be like, okay, whatever, because in my position it's murder, and another person's position is not, but it's all about a fundamental right, right? So one of the things that's a compelling argument, no matter what position you take about the idea of being allowed to, have access to the ability to do abortion procedure, is the fact that, hey, at least it's the government not infringing upon a right. You take that right away. I mean, you have to have such a compelling interest, and a lot of people who oppose abortion believe that they do have a compelling interest, but you have to have such a compelling interest that you're willing to give up a right to no longer have that as something you can do. And that's an important thing to consider. That has to be considered before you should just write it off as something that you no longer want to be legal in this country. Same thing with guns. If you don't want guns to be legal in this country, then you have to understand that what you're doing is you're giving up a right and essentially giving up power to the government. Now, that might be something that you want for the sake of security. However, there is a give and take there.
I think I just hear the words of Franklin echoing off these nice echo chambered walls, which is just don't give up liberty for freedom, right? For safety. It's such a. I feel like from a personal perspective, and I won't go too far into that, but it's not any. The government is not the surrogate that we should defer all decision making to, or all concerns for safety, right? We have things in place. We have the police, for instance, that you can call 911 an emergency, and they'll send someone out, and they'll hopefully whatever the situation will either de-escalate or be resolved. But it's not a guarantee. There's nothing guaranteed about that. So I think if you bring it all the way back, and that ties into some of the more I think philosophical values with respect to individualism and personal autonomy, right? And having the ability to, live your own life, pave your own way, and defend yourself. And a firearm is really the great equalizer, right? So there's plenty of ways that translates into pros, advantages with respect to crime and deterring crime, right? Or the fact that 55% of criminals will actually run away or flee in the event that someone that's being attacked will pull out a firearm in self-defense. These are things that are you can't untie it, right? They're all
right
together with that,
right? And I guess the counterpoint there would be for the people who oppose guns generally would be, well, you do have a situation where if someone's being attacked and the victim brandishes a weapon, that person's more likely to run away. However, if guns are available, you also have more violent crime with the use of a gun.
You have more violent crime with the use of a gun. I don't know that you could necessarily say that just because guns are available that criminals will have them.
Okay.
Right? Because I think the majority of those they may be break-ins, for instance, right? They're not intending violence upon the inhabitants of the home. They're just looking to steal something, maybe, right? So I think that we have to put it in context in that these sorts of crimes where they're inherently violent, right, to a high level where you're looking to actually hurt someone or kill someone, right? Those are very rare, and in the grand scheme, right? Whereas all these other sorts of things, I think, are much more frequent, right? They happen frequently as compared to these others, or these more violent crimes. The fact that the matter is, I think, for a lot of folks that are pro Second Amendment, is that's a symbol of their freedom.
Well, and I guess the other point to that is, I guess you couldn't really quantify how many crimes don't happen because it's suspected that the victim is armed.
Sure, exactly.
So not necessarily the crimes in progress, but crimes that could have happened, crimes of opportunity. But I can guarantee you that if I was driving through the great state of Texas, that if I was a person who was thinking about robbing a convenience store, I probably wouldn't do it because in my head, I'm in Texas, and that guy behind the counter has a big old shotgun, and it's going to stop me in my tracks.
Part of that is thinking like a rational person, Brenton. And I don't think someone that is otherwise going to rob a convenience store is of the same rationale, right? But I mean, yeah, don't rob anybody in Texas. Everybody has guns. But see, that's the point, right? Is that there is this sort of maybe just thought that hey, I don't know what to expect from these people. This is an area where I know people aren't going to back down. This isn't a victim mentality. These people aren't going to, there's no duty to retreat. You hear about that in law or the stand your ground states. Does this person, are they likely to be an easy target? I imagine that's the sort of thing that people are going to, that a criminal might look at in terms of whether they're going to be successful. They don't want to get caught, right?
Right. And how much violence is related to organized crime, whether it's cartel, gang activity, things like that, where if you eliminated the legalization of firearms, then you don't necessarily eliminate the black market for firearms. So you can really deprive those individuals of guns. That's another argument to think about, because which is a good argument, because if these people can, a lot of the weapons they have in the first place are black market weapons. It's not like making guns illegal is going to stop that.
What you're talking about, Brenton, is really prohibition and whether that's an effective mechanism.
Right.
And I think that time has shown that it's not.
Right.
But sometimes it's necessary, right? If you have some sort of substance that is only designed to destroy or kill, right?
Right.
Not necessarily to defend, for instance, right? Because you can make that argument. Well, guns are just designed to kill, right? But it's merely a tool, right? If you have something like this weird. There's a weird drug, some sort of crocodile nickname or something over. Crocodile. Over in like Eastern Europe is where I've heard about it. But it's really, like
it's in Florida, bro.
it's probably everywhere at this point, right?
Yeah.
If you touch it or if you use it in some sort of way, it just starts to decay your body.
Yep.
Right. You just start decaying. To me, those sorts of things.
They're because it turns into a crocodile. That's what you look like.
There's a difference in having that sort of access, or that should be available to anyone.
Right.
And notwithstanding that your freedom to do as you please to your body or consume what you like. So there are some things inherently that are designed, or the sole purpose is only to destroy.
Here's my fear too of the making a gun ownership illegal in many different forms, whether it's a total prohibition or making it illegal in to carry or whatever it is.
Right.
So we're talking about prohibition. The war on drugs we know is a failure. We know that we poured a lot of money in there. There's a lot of corruption, but the biggest failure was the mass incarceration.
Mm-hmm.
Someone gets popped with a dime bag and goes to jail. That's ridiculous, right? Just have a little bit of marijuana on them, and they can go to jail and be in jail for quite a long time and end up staying in jail because maybe something happens in jail, and they go in there and they learn to be criminals. That whole discussion. And mass incarceration in general, we just shouldn't have as many people as we have or have had in jail. And it was a total failure for that part, and that part, not just alone, but mostly that part. So that being said, if we make guns illegal, what is that going to do? It can absolutely lead to the same thing, mass incarceration. You might think to yourself, okay, well, if we make guns illegal, then it's not going to be a felony to have it. It's not going to be a high-class misdemeanor where it could lead to jail time. But the thing is that it's not just the initial underlying offense that leads to jail time. It's the fact that you pop somebody with an offense like that, you slap a misdemeanor on there, and what if they get a failure to appear? What if if they're too poor to pay the fine? They start getting things stacked on them, and that's what leads to the mass incarceration. just like with drugs. I mean, someone in California, might get popped with a dime bag, and that doesn't lead to jail initially, but then they don't show up for the court date, or they're not able to pay their fine, that sort of thing. And so it can lead to a cascade effect of what we've seen with our other prohibitions.
Correct. I would agree. I think that, being in the unique position that we are in our professional lives, we can see how easily those sorts of things can spiral out of control. It can have unintended consequences, right? Where you don't respond to, notice to file, right? For instance, or there's a subpoena, or there's, some sort of show cause. And then next thing you know, things have taken, gone from one level and it's been ratcheted up 3 or 4. So does that have some sort of, disparate impact on peoples of color, or, the majority of people that inhabit the prison systems? And then you've got the whole concerns about, private prison systems.
Right.
How that, and is there some sort of motive involved? And I know that, not to sound like some sort of, person on the fringe, but, I think that those are reasonable causes for concern that might, should raise an eyebrow and say, hey, what's really going on here?
Yeah, I mean, it would be incumbent upon those who intend to prohibit gun ownership to look at the possible disparate effect on people of color and people of limited means, and which is incredibly important. And you might be thinking to yourself, well, okay, well, if we can't make something illegal because it leads to mass incarceration or whatever, well, isn't that an underlying issue with our country and the way we set up our prison systems, and not an underlying issue with making something illegal? Because obviously we should be able to make some things illegal. And certainly that's true. And certainly there is something wrong underlying with our country and the fact that we have mass incarceration in the first place. But unless we fix that, it's not a good idea to have some type of prohibition. And the other thing too is, like, we know generally that a prohibition on something, a fast and hard prohibition on something, is not necessarily a deterrent for it. And it can also lead to, someone getting a record. I mean, heck, Oregon just made crack legal in limited sizes, you know what I'm saying? But I mean, they legalized it because they knew that, hey, if these people who have this, it's not worth the time and resources to prosecute, people for this small of a amount of a even dangerous substance. So that's the other thing, is how much time and resources will our government be spending American people's tax dollars to, enforce some type of prohibition like that?
Right. And from my perspective, Brenton, I don't see that changing. I guess we are seeing some change with, places like Oregon, that, I mean, I don't know. I don't know if I agree with that policy. Maybe, from what I as an attorney, I get it. I see both sides, but then just as an individual, I kind of have my own motivations for why I might lean one way or the other. Maybe connected with my kids, my family, things like that. But nonetheless, my thoughts on the matter necessarily aren't something that dictate your right. Right? It shouldn't sway into your fundamental rights. Right? My opinion, my belief, and how I act and conduct myself isn't something that that I should force upon you.
Exactly. I guess the idea of having a free democratic government, even a representative democracy, is that to fully enjoy the rights that you have to also, be cool with the rights that other people have that you don't really,
mind your business.
Yeah, it's mind your business. Yeah, it is.
It's not hard to do that.
It's not hard to mind your business. Yeah, I don't think the question's answered. I think there's a lot of sticky points out there with respect to gun ownership.
Oh, sure.
I think another thing is, if we're talking about gun ownership too, I mean, obviously people shouldn't own bazookas.
Sure. Why?
You know? I mean,
weapon of mass destruction, right?
right.
What sort of legitimate use would you have for that, for any sort of self-defense, sport shooting, right? Any of the above.
Right. Exactly. And I understand, I mean, I think we should cast a cautious eye towards limiting the type of firearms that people are allowed to have. However, I understand certain things like limits on, magazine capacity and things like that. Like, I get it. Okay. And there's certain things out there that if we're going to have a give and take with respect to the Second Amendment, and we're going to allow guns that, we have to we have to understand, I think that being a purist with respect to the right is something that, it is just not realistic. I think you should start and err on the side of saying, okay, like an infringement is an infringement unless you can show me is certainly a compelling interest. But once you see that compelling interest and it's narrowly tailored, then, it's a good thing to just adopt that and move on.
Sure.
Because if we do have more mass shootings and things like that, then maybe we should think to ourselves, okay, well, how are these guys able to shoot so many people at once?
Right. Yeah. I mean, there's some practical, I think really what you're getting at, some practical points with regard to common sense gun control, which is essentially what that is, right? If we've identified these issues, these events that keep popping up in society, where multiple people are being killed all at once, horrible situations, right? The question might be, well, how can we prevent that? Okay, and I would agree that to one extent, it's not unreasonable to say, well, hey, maybe we should limit magazines and keep people from being able to shoot 25 rounds in the matter of, in under 30 seconds, right?
Yeah.
Or you could have the thought that, well, what brought us there to begin with, right? Because when we do that, yes, we address an immediate practical or offer an immediate practical solution, but are we addressing the underlying cause behind why that happened, right? And I know that that's a much more in-depth discussion, and it's mostly circumstantial when it comes to all those sorts of things.
Right.
So a blanket approach might be, let's just cut availability, or let's throw a tax on ammunition, right? Something that would make the availability less, or make what you actually have, you just have less quantity, right? So you still hit those points of, well, I can use it for self-defense and other things, but I can't use it for mass destruction. So there's a happy middle ground that's been established, but are we really addressing the core of the issue, right? And
it also stands to reason that a trained individual, which typically a trained individual respects guns more, and a disciplined individual typically isn't your mass shooter, but just assume with me for
your average gun owner, Brenton, is a law-abiding citizen. Right.
And, but it does stand to reason that it's important for individuals to educate themselves on the subject and understand how guns work and what it means. I mean, a lot of people will see a AR-15 and see a 223, and one's an assault rifle and one's for hunting and sport, but they're the same round. both a 5.56 round, essentially interchangeable. And, one looks scary and the other looks like you're going to shoot a deer with it, And so, in our minds and in the minds of people who are educated about guns, and you see something saying, oh, we should, outlaw or prohibit assault weapons. And you're like, well, I don't know what you're talking about, and I feel like you don't know what you're talking about. I think that's scary for people who are pro-gun rights, because they don't feel like the people who want to change the law are educated about it, and it scares them.
Sure.
It scares them because, again, they want to limit the amount of infringement there, and they, when they hear people talking about it, and those people obviously don't know what they're talking about, it can be a very scary thing. It can be. It's just like arguing about any other type of law where you don't understand the underlying functionality of what you're talking about. Whether it's,
power of appointment.
Yeah, power of appointment. Jeez, does anyone know power of appointment? I don't think they do. But yeah, that being said, I think that gun ownership is an incredibly interesting thing. It's here. It's probably here to stay. I think the Supreme Court's about to take up a case, a New York case. That's why I mentioned New York earlier. A New York case that limits, I'm pretty sure, the availability of gun permits for individuals, very similar to the Heller case. It's expected that New York law is going to be struck down, given the composition of the Supreme Court right now. So Second Amendment is very likely here to stay, very likely is going to stay as strong as it is right now. And really, if we wanted to change that, I mean, how would we change that as a nation? Let's assume that our mores, our social, ideals have changed as a nation. What the heck should we do if we don't want the Second Amendment?
Sure. Yeah.
What should we do? I mean, do you know?
Follow the process. Follow the process that's already been put in place.
Yeah.
Look at when we had prohibition for alcohol, right back in the 30s, 20s, 30s.
Started with the 18th Amendment.
And then what happened?
Ended with the 21st.
Exactly. Right.
Right.
I think that would be the built-in.
We were like, we're gonna let women vote, and by the way, we're gonna have our alcohol, right? So we had 20. No one remembers what that one was because they were all too drunk. They forgot it.
I'm a little curious about the timing of that one now. So yeah, I mean, I think that you follow the process that's been implemented, that's been made available, and that you do it in accordance with the Constitution and how it lays that out, right? And I think that a lot of the discussion today, and there's plenty more pros and cons that we didn't talk about, and specifically because this discussion's been going on for a long time, right? This isn't anything new, especially anytime something tragic happens. Unfortunately, that becomes the political bludgeon that politicians will then use to hit their opponents over their head to push their agenda, and I really hate seeing that. It makes sense that things happening cause people to think about certain things, right? But the usury there, I don't like that.
Yeah, it's what bothers me about it is what I see is a politician saying, "Hey, look at this. You should give me the power to step outside of my lane and change the law in a way that is antithetical to the ideals of a democracy."
Sure.
We set up a way that you can amend the Constitution if you want, and we can. Mm-hmm. I mean, if we really wanted to as a nation, we would amend that Constitution. Heck, we've done it 27 times. Mm-hmm. Doesn't say we can't do it again. So, what bothers me about it, I would be the same. I'd take the same position. If we pass an amendment to outlaw guns, number one, I'd be like, all right, first one to say, okay, I'm cool with it. 'Cause that's what we voted on as a country, and that's constitutional law now. Also, though, if we had politicians coming out and saying they outlawed guns and this, watch how, this story on the news, how this person was killed and they could have defended themselves if they had a gun, and we should bring guns back.
All you'd say.
You should allow me to do that. I would be livid in saying, look, you should call for a constitutional amendment. You shouldn't try to use backdoor politics to get something done, to get voted in the office. I just think that's ridiculous.
I feel like that's Washington now anyway. But nonetheless, I think the more real probability is that gun control or gun, the ownership of guns, gun ownership will be most affected by tax and or availability. In my opinion, those are the softer, more accessible ways to control gun ownership.
Right.
How expensive is ammunition right now?
Yeah, I mean, if you have
You don't go to the range and
1,000 rounds of 9mm, you are a rich man.
that's what I mean. You don't go to the range and shoot off 1,000 rounds anymore. Not right now. And maybe that changes, maybe it doesn't. But either way, I think that's a real. I mean, and there's a lot of different reasons for that. But that's a really good look at, an immediate change to accessibility. And what does that mean for the average gun owner?
Right. Yeah, I mean, and that's not something necessarily against either. I mean, the tax code is all about incentivizing people to do things that the government wants. And really, that's a lot of power that the government does have. What?
Is it incentivizing or is it punishing? Or
Well,
is it theft?
Well, some people claim that it's certainly.
I'm just saying.
We claim that it is theft. But I will say though that those limitations are understandable. I mean, I get it. If I'm a person wanting to shoot off 1,000 rounds, it's going to piss me off. But I also get regulation that is not necessarily infringement. Now you pile on tax and tax and tax. You put people out of business because they're not buying ammunition and people can't sell ammunition, and that's another thing. I think that's a bad thing. And so I get regulation within reason. And I'm not saying that that's not something that should happen or can happen, but I think overall that, those are just putting a Band-Aid over the perceived bullet hole if you are, anti-gun. I think that what you need to do is follow the procedure, just like any other thing we want to change.
I agree. I would wholeheartedly agree with that. My thought is just from a very, very practical perspective. I think that's how that agenda is going to get pushed, right? If you're anti-Second Amendment, then you're looking at ways to immediately address gun ownership, the prevalence of guns in society, and how to minimize that or negate it. Right?
Which, by the way, it is okay if you're anti-Second Amendment. It's okay if you're pro-Second Amendment. There are good reasons why an individual would be anti or pro. And certainly I get both sides and why there's concerns and about people being able to have guns. I mean, heck, I drive on the road sometimes, people cut me off and I'm like, oh my God, that person's allowed to own a gun. It's kind of scary. At the same time, there's a whole, rights thing that we're talking about too, and the protection of rights. And, I think there's compelling, views on each side. And I think though that the overall theme of this discussion is not necessarily whether it's right or wrong to have the Second Amendment in its form that we have now. It's how do we function as a country and how do we implement change correctly? Sure. So that being said,
I agree.
This has been episode 2 of PhiLAWsophy, where we've discussed in detail the Second Amendment. And next time, I think we've decided that we're going to discuss privacy. So we're coming after you, Facebook.
Sounds like fun.
I feel like my computer was just about to shut down on me. Right?
You said the magic word, and then it started listening.
Yeah, the NSA is in Siri are both checking me out right now. So if we are not thrown in Guantanamo after episode 3, there will be an episode 4, and where we will talk about something else controversial with regard to constitutional law. Therron, thanks, man.
Thanks, Brenton.
All right, see you.
Yeah.